There are 5 new tests that USCIS is now using to decide your green card application. Most of these did not exist even a year ago. And right now, every single one of these is catching people off guard. My name is Mamita Rahman. I have been helping immigrants across the United States for the past 16 years successfully reach legal status. And my office handles these cases every single day. So in real time, I see exactly what USCIS is deciding, how they're deciding it, and what we need to do to prepare clients' cases. In this video, I'm going to show you the 5 new tests that USCIS is putting every immigrant application through, how officers are using these tests to deny cases, and exactly what you need to do to pass each one of them. And as a bonus, I'm going to reveal at the end brand new questions that officers have started to ask at interviews, which you don't want to miss. To start, I'm going to show you the first test that everything is built upon. On May 21st, 2026, USCIS released a policy memo with an extremely long name. Adjustment of status is a matter of discretion and administrative grace, and an extraordinary relief that permits applicants to dispense with ordinary consular visa process. And as soon as USCIS released this memo, the entire immigrant community went into a crisis mode. Because until now, if you met the legal requirements, a real marriage, a valid petition, no disqualifying problems, you got approved. But this memo changed that. It said that a green card in the United States is an act of administrative grace, a favor that the government can choose to give you or not give you. So now, according to this policy memo, an immigration officer can deny your case even if you meet every single legal requirement. And within days of this memo being published, law offices all over the country started receiving a brand new type of RFE on pending green card cases, demanding 2 things: proof of why USCIS should use discretion in your favor, and proof that you can support yourself financially, which I'll get into later in this video. Nobody was getting letters like this before. So how does an officer decide whether or not you should get a green card? They weigh heavily the positive factors in your file against the negative ones. And USCIS has published exactly what they believe to be in your favor and what is not in your favor. What counts in your favor are family ties in the United States, and a U.S. citizen spouse or U.S. citizen children carry the most weight of them all. The hardship your family would suffer if you were denied, years of lawful residence, especially if you came here young, a steady work history, or paying taxes every single year, your education, your skills, or owning a home or business, serving your community, your church, your mosque, volunteering, helping others, and a clean immigration record. On the negative side, officers are looking at overstaying a visa or any time spent in the country without status, working without authorization, using your visa for something that it wasn't meant for, like enrolling in a school while on a tourist visa, arrests or criminal history even from years ago, and anything you told an immigration officer at the consulate, at the border, or on a form that turned out to not be true. So what should you do to protect yourself? You build what is now being called a discretionary evidence packet, a second layer of your case whose whole job it is to answer one single question: why should USCIS say yes to you? Some examples of things that you might want to include are letters from your employer, your neighbors, your pastors, anyone who can say this is a good person who matters to the community. Your tax returns going back years, birth certificates of your US-born children, a letter explaining in great detail what would happen to your family if you were not to be approved, and proof of anything that you have built here: your home, your business, your degree, your professional licenses. They basically want to find out whether or not you are an asset to the United States. Note that if you already filed without this information, you can still supplement your case, and you can even provide this information only if you get an RFE. But of course, better be safe than sorry, and try to add in as much of this evidence about your positive equities as you can from the start. That brings us to the second test, which is catching people off guard. When an officer opens your case today, your complete immigration record is sitting right there on their screen. Every visa application you have ever submitted, including the notes from your consular interview, what you told the CBP officer every time you entered the country, and every single case you ever filed with USCIS. The government always had these records, but they were spread across separate systems that did not talk to each other. But that changed this year, and their systems are now fully connected. And the memo I just showed you specifically says anything that does not match what you told a consular officer or a border officer is one of the most serious negative factors in your case. On top of that, one more protection is also now gone. For years, if USCIS had approved something for you, officers trusted that decision and did not reopen settled questions of law. Today, every new filing has to stand on its own. So if you're thinking, I've already been approved 3 times before, my history is solid, that's no longer how they see it. Every page you have ever submitted is being re-seen with fresh eyes. And the first thing they're looking for is proof that the negative factors exist. So if you ever overstayed, worked without authorization, or used your visa for something it wasn't meant for, they're going to find it on old records or old forms. They're also looking for problems that aren't violations at all. The most common one are inconsistencies between your forms. Let's say that your old form says that you were a marketing assistant, but your new one says that you're running the whole department during this entire time. Now they want to see which one is true and why are they not the same. They're also digging up old applications you forgot about, even ones that were never decided, and comparing every answer in them against what you are saying now. And finally, they are looking at prior visa denials. If you were ever denied a visa, even if it was more than 10 years ago, you must disclose it on your new forms. Leaving it out can be treated as a misrepresentation, and that can sink a case all by itself. Now, you cannot change what is in your old forms, but you can still find out what was on them to make sure that everything is consistent and fully disclosed. So consider filing what is called a FOIA request, a free request that forces the government to send you a copy of your own immigration file. You can file it at uscis.gov or by mail. And if you ever applied for visas through a U.S. consulate, request those records to the Department of State also. Then compare everything against each other and ask yourself, if an officer put these two side by side, would things add up? If you find a problem, try not to bury them. An inconsistency that you disclose up front and explain is better than one that you have to be on the defense about later, because the same inconsistency discovered by an officer after the fact creates a credibility problem for you. And once your credibility is questioned, they can look at everything in a much more negative light. The third test is something that most people would never guess about because it has nothing to do with your paperwork, but officers are now looking at things that you have posted online. Social media screening used to only apply to a handful of visa categories, but over the past year, the government expanded again and again. And at this point, it covers virtually every immigration benefit: green cards, work permits, citizenships, family petitions, all of it. Now, when you file, you are required to list every social media username you've ever used in the past 5 years, every account you forgot about or have not opened in years. And as of February 2026, it goes even further than your own accounts. Officers can now review your family members' accounts as well. So if your mom back home posts something like, "So excited for my daughter's new life in America," the same week you enter on a tourist visa, that post can end up in your file. Now, let's get exactly into what officers are flagging when they go through these accounts. Biggest one is posts that reveal your intentions. If you entered on the tourist visa and posted, "Finally made it to my new home 3 days after entering the United States," that post can be evidence of misrepresentation. They're also flagging evidence of unauthorized work, like a hairstyling page that says, "DM me to book," or an Etsy shop under your name. And if you have a marriage case, they are comparing your accounts against your relationship. If you claim 3 years together, but neither of you has a single photo of the other, or your relationship statuses don't match, officers notice. They're also flagging anything that contradicts your forms, like a LinkedIn job that does not match your petition, or a location tag placing you somewhere that your application says that you were not. Now, I know what you're probably thinking right now. I'm just going to delete everything to be safe. Please think twice before doing that. Deleting your accounts before you file is one of the worst moves that you can make. If an account you disclose on an old form is suddenly gone, officers may treat evidence of that removal as evidence that you are hiding something. Plus, deleting something doesn't even work. Archives and government tools can preserve information long after you think it's gone. So instead, you audit. Go through every platform 5 years back, posts, captions, location tags, even photos you're tagged in. And if you find something that contradicts your case, don't erase it. Instead, prepare an honest written application with your attorney before an officer asks. And since officers can read your family's accounts too, you need to get ahead of that as well. Before you file, have a conversation with your family and ask them to not post about your case or your plans. And make sure that your stories and accounts tell the same thing, that your application application does, because I guarantee you, officers will probably be reading both. Next, the fourth one is the financial one. Officers now want more proof that you can support yourself. Remember those two-part RFEs I mentioned at the beginning? The second thing they demand is evidence that you will not become what is called a public charge, someone who depends on the government to survive. Now, public charge rules have existed for a very long time. Before, if your sponsor's paperwork showed enough income, that was usually the end of it. But today, officers are demanding proof up front that you can actually support yourself financially, and some people who filed that the evidence are getting RFEs, delays, and denials. So how do they decide whether or not you pass the financial test? Officers weigh your whole financial picture, including your income, your assets, your education level, your skill sets, your health coverage, your certifications, and the size of your household. No single factor can sink you. They look at everything together, asking one question: is this person likely to depend on the government in the future, or are they likely to be able to support themselves? And this question is the one that you can answer before they even ask. Simply build a financial evidence package into your case. Your most recent tax return, recent pay stubs, a letter from your employer confirming your salary and job title and history, bank statements, proof of health insurance, certifications for any training and diplomas. And if you have them, evidence of a home, savings, a retirement account, a degree, and any professional license. Also, your sponsor's affidavit of support, the I-864, still matters enormously over here. They still need to have income that is at least 125% of the poverty level for your household size. And if your sponsor's income falls short, you can still add a joint sponsor, someone who does not even need to be related to you. If your household income is at or above 250% of the poverty guidelines, USCIS treats this as a heavily positive factor. And for most cases, the financial conversation essentially becomes over. For a family of 4, this is $82,000 a year. If you're there, put that evidence on page 1. The fifth and final test is one that USCIS stopped putting most people through years ago: the interview. From about 2018 to 2024, USCIS waived interviews for huge numbers of green card applicants. If your paperwork looked clean, then you filed, you waited, and a green card sometimes just magically appeared in your mailbox. But in 2026, this is now gone. Marriage-based green cards are now interviewed over 90% of the time. And people who filed years ago expecting a waiver are instead receiving interview notices to appear. So whatever category you are in, be prepared as of though you will be called for an interview. And when your notice arrives, understand that your interview will be different from the ones that people were getting several years ago. The officer walks in having already read everything: your old form, your CBP entry notes, and even your social media. Then they ask you questions for things they already know the answers to. If your answers do not match your record, even on something small, you have handed them a negative factor and an excuse to treat you with an X-ray. And that is why it is important for you to anticipate the new questions officers are asking before you walk in there. So let me show you some of the questions that you can expect at the interview. The first group is discretion questions like: why did you apply for a green card from inside the United States instead of through the consulate in your home country? And what would prevent you from going abroad in your case? A strong answer might be: my 2 children are U.S. citizens in elementary schools here. I'm their primary caregiver, and consular processing would separate us for months or longer. The idea is to name the specific reasons why leaving would harm your life: kids, your job, home, whichever ones actually apply to you. And if leaving the country would trigger a legal bar that keeps you from coming back, that is also a very strong answer that you can explain. The second group of questions are entry intent questions like: did you have plans to stay here permanently when you first entered? And what was your relationship with your spouse before you came to the United States? Be very careful here, because what your plans and what your intentions were at the time can change whether or not you get accused of misrepresentation, which would require a waiver. Tell the truth about what your plans were and explain how they may have changed from the date that you stepped foot in the US. When your plans generally evolve after you get here, that story, told honestly with real dates, is the legal will answer. The third group is compliance questions like, have you maintained your status without interruption? Have you worked without authorization? And have you paid your taxes every single year that you've been here? If there's a violation in your past, own it and pivot it to everything you have done right since then. Every one of these answers has to line up with the file sitting in front of the officer. That is why reading your own file, the FOIA request I talked to you about earlier, is also important when getting ready for the interview. Get your file compared against your forms and evidence and timelines and make sure everything is consistent. My name is Mamita Rahman and I have been a practicing immigration lawyer for the past 16 years. If you would like my help on your case, you can give me a call and schedule a case evaluation at 212-248-7907. We are based in New York and we serve clients all over the US. Now, these 5 tests are how USCIS decides your case before it gets approved. But even after you win your green card, there are still 10 ways that it can be taken away from you. And most people fall into this trap without ever realizing they were at risk. So in my other video, I break down the top 10 mistakes that USCIS is looking for right now and what to do to protect the green card that you have worked so hard to get. I'll include a link to that video here. Click to watch it next and I'll see you there.